and lots of process things are happening, which are very important and starting to lay the groundwork for how we will operate as a board going forward very, very soon, I hope. So I do not believe there's any old business for us to discuss, but I did want to start on some new business, which would start off with an update on where we are with publishing of the regulations, and there's very good news here. So I'm going to ask Christina Sacco from the Office of the General Counsel to update us on that.
Good morning, everyone. Thank you all for being here today. We're very excited to announce that we have published the regulations for the Clemency Board on the DC Register that went live on August 13th, 2021. So they're out for notice and comment for 30 days. Notice and comment will conclude on the 13th of September 2021. At that point, we will consider and respond to comments. Those comments will then be processed. We will revise the regulations as see fit and consider the comments we do receive. From then on, it'll go through an internal review process here at the mayor's office, and then we would issue a final regulation in the DC Register. For those who are interested in submitting comments with respect to the regulations, you can access the regulations by doing a Google search of the DC Register. The first link that will pop up will be to the DC Register. If you click that, and on the column to the right, at the very bottom, you'll see proposed rulemakings, and you'll see 3 current proposed rulemakings are out for notice and comment. If you click on that number 3, it will take you directly to all the current proposed regulations. The first one is from the Mayor's Office of General Counsel, and that's the one concerning the regulations for the Clemency Board. At the bottom of the regulations, it will indicate how you may submit those notice and comments. That can be done via mail to the Office of General Counsel. We provided the address at the bottom of the regulations. You may also submit notice and comments via email at clemency.dc.gov. And we're happy to receive them via email or mail. So we look forward to receiving those comments. Thank you.
Thank you very much for that update. It's really good news that they've been published, that they're out for comments until September 13th. So this is significant progress and really allows us to move forward very quickly from here. I wonder if any of the board members have any questions for Christina or for the members of regarding the publication of the regs. Okay, I'm not seeing any, so we'll move on. So as we approved at our last meeting, there are 3 committees that were established to, again, further the work of the board. The first of those committees is the Applications Committee. And so I would ask that Deputy Attorney General for Legislative Affairs and Policy, Emily Benston, do a quick update of the activities of that committee.
Sure. Good morning, everyone. The Application Committee met a couple of times recently, both on August 24th and August 30th, to review a draft of our application. Did want to note here that the way the application is structured is that is a supplement to the application that the Office of the Pardon Attorney uses. And the way both the regs are drafted right now and the application is drafted is that the person seeking clemency would first fill out the DOJ application, and then that application would get forwarded to us from the Office of the Pardon Attorney, and that we have sort of a supplemental application that that we ask the person to fill out. Because those are so intertwined, I wanted to spend just a few minutes talking about why we had come to that conclusion and the approach that we're taking. I think, as everyone here knows, the DC code that set up the Clemency Board requires the board to send its recommendation for clemency. Of course, we can't actually grant clemency because we're not a state. All we can do is recommend clemency, recommend that the President of the United States grant clemency. The DC code requires the board to send its recommendation for clemency both directly to the President of the United States and to the Office of the Pardon Attorney at the Department of Justice. So the idea here is that we make our own independent recommendation. In conversations with the pardon attorney, I understand that members of this board that the pardon attorney has said that the recommendation of the clemency board would weigh very heavily in its recommendation to the president of whether or not to grant clemency. So that's wonderful. Of course, it doesn't relieve us of our obligation to make our own recommendation to the president. In part, it's important to note, aside from the fact that the DC code requires it, that the clemency board, the Office of the Pardon Attorney, unless it is recommending clemency, doesn't send anything to the White House. It only sends something to the White House if it is recommending clemency. And so the Office of the Pardon Attorney wouldn't see our recommendation unless the Office of the Pardon Attorney agreed with it, unless we separately sent our recommendation to the president, which we'll do in part because the DC code requires it. All of that being said, the practical reality of it is right now that there is no mechanism for the White House to review applications that come directly from the board. And so our thinking was that at least in the short term, in order for somebody to be seriously considered for clemency, the person needs to have filled out the DOJ application. Other members of this board has pointed out that it's important that the DOJ application be filled out for any people convicted of DC code offenses to be considered in any DOJ sort of initiatives with regard to release. And so the idea here is that in order to ensure that the person actually is seriously considered for clemency, that they fill out the DOJ application, and that our application is a supplement to that. We've also heard and we understand that there are significant downsides to using the DOJ application. And so at least my view is that if circumstances change such that there is a mechanism for the White House counsel to review recommendations from the clemency board separate from the OPA process, we should consider perhaps using a different application process. But for now, that is where we are. One thing that just to note for the board, I've learned it at least since the last time we all convened, is that there are some issues with the DOJ application about whether or not it actually can be filled out in a way that applies to DC code offenders. The example that was used is that, for example, one of the first questions is, in what district were you convicted, and has a bunch of checkboxes, and none of those checkboxes is DC. So my recommendation is that we would talk to the pardon attorney about at least modifying the application to make it applicable to DC folks who are convicted of DC code offenses. So that is how we ended up with that process. Our application, the clemency board draft application, is quite short. It is meant to simply gather some additional background information and to much of which goes to whether or not the person actually is eligible for clemency under the DC code. So that is where we are. The idea is that it would become finalized once the regulations become final. I don't know whether or not there was a plan on this call, Patrick or Christina, to actually walk through the draft application in this meeting. But in any event, that's sort of our remarks about the application and how we came to have the application that we do.
Thanks very much for that. Appreciate it. And it is new information in terms of, when the review of the statute showed that we do write our own letter to the president. And I think that's an important thing that was really well discussed in the application committee. So thanks for that. Christina, do you want to talk about the plan around discussion of the application?
Sure. So initially, we want to be able to open up discussions to the full board for a vote on the application. Once that's finalized, yes, we will. We'll be more than willing to do a review of the application at a full public board meeting once the regulations are finalized.
Great. Thank you for that.
And I just want to add one more thing with respect to the application. Emily is correct. It is a supplement to the DOJ application, but we want to place strong emphasis that it is after you submitted a DOJ application that you submit an application with the DC Clemency Board for a letter of recommendation. So we do need that to happen first So the DOJ application needs to happen first for us to even consider a application for a letter of recommendation. And we've placed strong emphasis on the fact that the DC Clemency Board application is simple, accessible, and is not filled with a bunch of legalese that you know, a layperson may be able to fill that out without any assistance. But we're hoping that we can also build out a mechanism for them to also receive some legal assistance with it. But it's a really short application, and we're looking forward to sharing that once we have it finalized.
Thank you. Is there discussion among other board members? Questions? Any other members of the application committee want to speak, please?
Patrick, just for clarification, this is Felisa. I just want to, so I understand the piece about a person who wants a letter of recommendation from the board first filling out an application with DOJ to get that letter. So are we also saying that the board, if a person chooses to just fill out an application, is there a possibility of a person filling out an application just with DC's board if they didn't want to go through the DOJ, or must they go through the DOJ, pardon, office?
So the place that we came to was that we should require them to fill out the DOJ application first. And the reason for that is the practical reality of it is the White House won't consider its clemency application right now that doesn't include the DOJ application that OPA requires. I at least am hopeful that that might change sometime in the future, in which case we might want to consider changing our application process. But as of right now, because there's no other mechanism for the White House to review the application, we don't want to end up in a situation where we send an application, the person has not filled out the DOJ application, and so the person who might otherwise get clemency is not seriously considered or considered at all by the White House because they didn't follow the OPA process.
So you must go through the OPA process in order to get a letter of recommendation from.
You have to fill out the DOJ application, right? The OPA process might be longer than that. You have to fill out the OPA application as part of our application. So you'd need to do the DOJ one first, and then DC's quite short supplemental application in order to get a letter of recommendation from the Clemency Board.
Anything else, Felisa?
Nope.
Okay.
No.
Reverend Sam?
I think Emily and Christina covered it all, but the brevity of our application would aid the residents that we're trying to reach, because we didn't want it to be a turnoff, you know, if they see another long form. So I think it's very friendly usually for our residents, and I think they would take advantage of it.
That's great. Yeah, I really appreciate the sensitivity the application committee had in drafting it in that way. You know, that is consistently what we've heard from the public, consistently what we've heard with people who routinely work in this arena. So yeah, I really appreciate that effort on that. Okay, any other questions on the application from the board? Okay, so next I'm going to ask Special Counsel for Policy at the Public Defender Service, Katya Semyonova, to talk about what occurred with the prioritization committee. I know they also met recently.
Sure. So the prioritization committee met on Tuesday, August 31st, so yesterday, and discussed the board's priorities, particularly the statutorily required priority groups, which are the elderly, the terminally ill, those who no longer pose a danger to the community, and those who were convicted under sentencing schemes that have since changed to provide for less severe penalties. The board is continuing, or the committee is continuing to study the groups and to develop the definitions, as well as looking at additional priority groups that should receive prioritization by the board.
Very good. Any other members of the committee want to speak? Or Andrew, we can't hear you. You're on mute.
Okay, I'm sorry. I thought I had pressed the button, new technology. I just add that the next step in our work is, as you, Patrick, envisioned it, is to reach out to various stakeholders and get advice from them as to what our priorities should be beyond the statutory requirements. And that'll include the mayor's office, other than the general counsel, the council, including the chairman, CSOSA, Pretrial Services Agency, the Criminal Justice Coordinating Council, and then we'll be back at you with those ideas. I hope to have another meeting soon, perhaps as soon as late this month, to take those next steps.
Fantastic. I assume too, this is going to be the kind of committee that, as circumstances change, as big public efforts change, the prioritization committee will probably need to be one that is ongoing over a longer period of time. Application will be, pretty much done for a while until, we get full statehood and have the ability for the mayor to pardon who she feels fit to do. But I think the prioritizations may change more frequently. So I see the ongoing work of this committee is really important. Any other questions or comments for the prioritization committee? Okay. All right. So the last committee that I want to raise is the Community Engagement Committee. The attorney member, background in returning citizens, and the Mayor Bowser's appointee, Felisa Carter. Lisa.
Good morning, everyone. We met, we've only had one meeting, and we met on Monday to discuss what our priorities will be. Well, we're using that word. Priorities will be for the upcoming year. So basically, when we met, it was as of now, but things will change as we meet more frequently, and get in touch with other. We identify other stakeholders in the community. But so far, what we did was we identified various stakeholders, government agencies, nonprofits, advocacy groups that would help get the word out about the Clemency Board, and how to best partner with these groups to get out the word about what we're doing and where we are, what our progress, what we do, what we can do, and just kind of getting the word out. And we're definitely looking forward to working with various groups. One of the things that we need to get out, will help that we get the word out, is people kind of letting me know who we think would be a good group or people, agency to contact regarding the Clemency Board. With the setup of our website, just want to get that out. Clemency@dc.gov. That is Clemency, CLEMENCY@dc.gov, to let us know about agencies or nonprofit groups you think would be a good person or organization to reach out to. So that's what we've done so far. And we have right now plan to reach out to various agencies to let them know we're out here, and kind of getting feedback about how to go forward with what we're doing.
That email is, you said clemency@dc.gov. I'm sorry, you're on mute now.
That's not our, I don't think that's our email. Do we have an email yet, Christina? That was just a website.
No, that is correct. It is an email address. So
email address is email
correct.
Address.
Yes. So we, as Felisa said, yes, we've been identifying stakeholders and having preliminary conversations about how we can do outreach and reach our target population and service, the District of Columbia. And one of the things we've realized is that we've engaged with government agencies, nonprofits, and advocacy groups. And so part of us making this announcement now is that if there's a particular advocacy group or agency you think should be a stakeholder in outreach for the Clemency Board, please email us at clemency@dc.gov.
Great. Any questions for the Community Engagement Group Committee?
I have a question, Patrick.
Yes.
Is the committee including the Bar Association and the defense lawyers community in the definition of community, or is that something I should write in an email, or is it already being considered?
So
I don't know.
Andy, yeah, thanks, Patrick. Andy, yes, you are correct. We are considering pro bono attorneys and clinics, and also the public defender services, as well as the prosecutor's office as stakeholders to reach out to.
Hey, there's also a Superior Court Trial Lawyers Association, which I think would be a good group, and the private bar association, the Bar Association of the District of Columbia, which is distinct from the bar. It's a voluntary association. Those might be two good groups as well.
Wonderful, thank you, Andy. Could you do you mind sending an email at clemency.dc.gov or to me? That would be great.
Sure.
Thank you.
No, that's really helpful. And I think any board member who, please feel free also, like if there are groups that you think that we should be touching right now at this early stage, that would be very important to start to gather any information. And if you could give us a contact to reach within that organization. I was lucky enough to do a presentation for a group called Voices for a Second Chance. Ms. Paula Thompson and Ms. Nancy Ware are very involved with this group for returning citizens, and I got to speak with them 3 or 4 weeks ago. A group of 6, they were all men, who have, are at various points in their return to the district and to this community, and to really hear from them about what they thought was important for our activities and how we could, best use these was really, really important. And it's something that I hope this board will always pay attention to very directly, is the community that we impact and affect. So I was really pleased to talk to Voices for a Second Chance. Any other comments on the community engagement? Questions? Okay, so we have an opportunity. We have some public members here on the board, or for the board meeting, and I wonder if there's anyone from the public who'd like to be recognized. Christina, you're going to have to help me technology-wise to figure out what has to happen. Christina, I'm not sure if you're speaking, but we can't hear you.
Oh, I'm sorry, I was speaking. I was going to go down the list alphabetically. So we have Adrienne Meningo here. Not sure if she's a public or coming in as a member of a designee office, but Adrienne, do you have any comments?
Yes, ma'am, I do. Can you hear me?
Yes, we can hear you.
Please go ahead.
Okay.
Welcome.
Thank you. Thank you. Good morning. My name is Adrienne Manigo, and I actually serve as a student attorney through the Howard University School of Law Reentry Clinic. And my colleagues in here and I are here today, as well as my professor, are here today to talk about the inconsistency between the Clemency Board Establishment Act of 2018 and the board's proposed regulations, the issues that DC co-defenders run into with the current DOJ application, and the importance of DC having autonomy over their citizens' clemency process. 1. This is the number of DC co-defenders that have received some form of clemency since 1989, 1,556. This is the number of federal offenders that have been granted clemency since 1989. As we can see, that's a very troubling statistic, and that is what I'm here to speak to today. The purpose behind the creation of the DC Clemency Board was to give DC co-defenders an actual chance at receiving clemency. This is a privilege that they have long lacked, and it is because they have to go through the federal clemency process instead of having a state-based system. Through the regulations the board has proposed, it still makes it nearly impossible for DC code offenders to receive some form of clemency. Instead of eliminating unnecessary steps to receive clemency, the way that the board is being utilized actually adds an additional one. The regulations set it so that applications that come from the board serve more as a letter of recommendation than an actual consideration for pardon and or commutation. This completely goes against the statute's intent. The intent and language of the statute would have it so that the board would serve as the primary vessel for recommending individuals to the White House Counsel and then to the President of the United States to receive some form of clemency. And if the board was utilized in this light, as is said in the statute, it would make it a lot easier for DC code offenders to receive clemency. And instead of just having one DC code offender receive clemency since 1989, we can finally do something about that statistic. And I would now like to pass it on to my colleague, Bridget Worlier, to talk more about the DOJ application, if that's okay. I didn't know if you still wanted to go alphabetically.
That's absolutely fine. Thank you.
Good morning. My name is Bridget Worlier, and I'm a student attorney with the Howard University School of Law Reentry Clinic. The proposed regulations are inconsistent with the language and intent of the statute. The Clemency Board Establishment Act of 2018 affirmatively provides that the Clemency Board is to establish its own applications for DC code offenders. It also provides that the board is to recommend successful applicants to the president and the pardon attorney. The Clemency Board Establishment Act also provides 6 things to consider in the creation and evaluation of the board's clemency application. The language of the statute clearly establishes an intent to have DC's Clemency Board function as an entity that reflects the values and goals of the district, while also centering DC code offenders as opposed to the previous process that left DC code offenders without relief for commutations and pardons. The recently proposed regulations are inconsistent with the statutes concerning the Clemency Board and intent of the Clemency Board, and here are 3 reasons why. First, the DOJ application is centered around federal offenders. The first page identifies the applicant as a federal prisoner. The application also asks for the name of the applicant's federal institution and names the United States District Court as the venue of conviction. Second, the DOJ application does not allow the board to consider individuals aging out of crime or individuals claiming actual innocence. The act specifically requires the board to consider applicants who are terminally ill or elderly, applicants that no longer present a danger to the community, and applicants claiming innocence. The DOJ application does not provide room for an applicant to speak on this criteria. Third, the DOJ application is difficult to fill out. The application that Howard University School of Law submitted to the board was written at a 5th grade reading level and includes signposts for applicants to complete the application with or without an attorney. It was written to allow people to put their best foot forward. It also provides room for applicants to seek support from an advocate if they are claiming actual innocence. Advocates have spent 4 years, and there is a lot of potential for the Clemency Board to be another ring in our efforts to create a clemency system that serves DC code offenders and support DC statehood by creating processes that reflect the district's value. And I'll now pass it along to my colleague, Lauren Jenkins.
Good morning, everybody. My name is Lauren Jenkins, and I'm also a student attorney with the Howard Reentry Clinic. I wanted to speak to you all today, focusing on the goal and intent of the DC Clemency Board and the legislation that passed the DC Clemency Board. The goal of this Clemency Board wasn't only to provide incarcerated citizens, violators of DC Code, a fair chance at clemency, but it was also supposed to provide a sense of autonomy to the citizens of DC. For far too long, DC residents have had no voice, no voting voice in Congress, and no control over who may re-enter their community. Every state in this country has control over who of their incarcerated citizens is granted a pardon or commutation in the form of the power of the governor. The Clemency Board is to provide some sense of that same control, but they cannot do that if the purpose they serve is only to provide recommendation to the office of the pardon attorney. With DC lacking the same governmental makeup and the president having that final say in granting clemency, it would only be right and fair for the people of DC to be granted the same form of autonomy in the form of the DC Clemency Council fast-tracking its own application from its board directly to White House Counsel. Like my colleague Adrian Manigo spoke about earlier, the DOJ has only granted clemency to one DC code offender since 1989, when in that same time, 1,556 applications have been granted to federal offenders. The barriers that exist causing this extremely high differential, namely DC code offenders not knowing how to begin this process and not being able to fill out the DOJ application without counsel, will only be exacerbated if there isn't more concision in the clemency process. Believing that sending DC code offenders through the same process in the DOJ will produce a different outcome is misguided. Adding yet another step to an already lengthy process will only create yet another barrier in the DC clemency process. It is in this board's best interest to edit the current regulations, allowing for DC clemency applications to be viewed and approved by the DC Clemency Board and sent directly to White House Counsel and then to the President of the United States for approval and denial. And I'm now going to pass it over to my professor, Josephine Ross.
So Ross, we can't hear you.
Okay, now you can hear me, but you still can't see me, right?
That's correct.
Okay, I keep hitting camera. I don't know. That's too bad. I dressed up special for this today. Okay. First of all, you should know Howard's been in this from the beginning. Like even before the board was created, we were brought in to assist the board. And when did we find out that there were even that there was this regulations posted? Not till I think it was this week, which is crazy. So first of all, that doesn't make sense because we've been coming to meetings asking about, when do we think the regulations are going to be finished and for us to have a look at them. So that is a problem. And if we don't know about it, how can the community know about it and really comment? September 12th is fast upon us. And I think that the three students who just spoke really laid out some of the issues. And what I want to do with my time is talk about where we go from here. Like, how do you change the regs? Because, I understand what was being said, that right now, at this minute, Biden and his administration is saying, assuming that you all really did your work of getting applications and making recommendations to the White House Counsel, Biden would still say, go through the OPA. And that being done, clearly that's what has to be done at this minute. But the regulations should not be written in stone for this to be from here on in, because there are major problems with just joining the herd. And I think some of them have been laid out, the difficulty in somebody filling out the application without any direction of what, putting their best foot forward. When we wrote the application, for example, we said, if you are innocent, and of course the board is supposed to look at innocent people as well, stop. Do not fill this out without a lawyer. There's nothing in the DOJ application that says that. I think at this point you could change your own application to say that you need that people should not fill out the DOJ application or your application without a lawyer if they're trying to claim innocence. So that's one thing, but mostly it should be, the regulations should be altered to allow a change in process as we finally get the ear of the president. Because the goal, and I think my student said this, right? This took 4 years of advocacy, not by me or Howard, but by the community groups to get this statute passed, with the idea of being able to have their own channel and create their own application that really focused on what you are all focusing on. You know, who should get priority? Who do we want to bring home? And to have it that the people have to do the DOJ application first in order for you even to look at it or help them doesn't make sense. Also, the statute gives a full-time staff person. And what is that staff person's job going to be or should be? I think my reading of the way the statute was written with the full-time staff person was to help somebody who is maybe not very good at reading, etc., to be able to fill out what they need to fill out and get the records they need. So when somebody applies to you and they have not filled out the DOJ application because they think it doesn't apply to them, or they, for whatever reason, it confuses them, but you, as you said, have a nice, easy application, great, they apply to you, and then the staff person can get all the records that are needed. That should not fall to the board itself. The board has a staff person to help them. And that way you can get a full review. And if it's a case that they should be applying to the DOJ also, then I think the staff person can help them navigate somebody with a really difficult time writing things out to explain what they're asking for in each box and so forth, if that is required, but it should not be required in the future. So yes, for right now, I understand why it's that way, but that is one of the, I think basically overall, the regs could be a lot more silent about some of these pathways, because it is going to change depending on who we have in the White House. And I asked the question too of how many people have applied. The impression I have is that you have very few DC code offenders applying. And I think that is because of the problems that the 3 Howard students just laid out for you about how difficult it is to fill out that application. But does anybody know the answer to how many are in the pipeline right now? So the question is, how many DC code offenders have actually already applied through the DOJ at this time?
It's Patrick Canavan, Professor Ross. I do not know the answer to that question right now. And I can tell you that we've started to have very substantive and I think very productive conversations with the pardon attorney and the office of the pardon attorney. So we look forward to that. I really appreciate all the comments, particularly of the student attorneys from the Howard University School of Law Reentry Clinic. It's fundamentally important that your voice is in this. And I just want to again say, as a citizen, a resident of the District of Columbia, how much I appreciate the efforts that have been made to make this clemency board come into existence because of all the work that's been done. We have, I think each board member has noted what you have just talked with us about, and I know that there will be consideration of these when that comes. There is the process, the legal process to give comment, and I would urge you to make sure that your voices are in that commenting process. I'm open to other members of the board right now. If any of you wanted to comment on something specific, there are a lot of points made. I think the most chilling one for me is the first fact, which is since 1989, one District of Columbia application has been granted. And I think all of us are committed to making that change. But other members of the board, if you'd like to comment.
Thanks, Dr. Canavan. This is Emily. I'll comment. I wanted to echo your thanks to the Howard students for bringing these really important things to our attention. I think it's really important that we address them. I think right now my view of the regs is that there's certain changes that we simply will be required to make because the DC code that that establishes the Clemency Board, as I mentioned, does require us to make an independent recommendation to the president. And I think we should do that both because it's what the code requires and also because I think it is the right thing for us to do. I think it is the purpose of the Clemency Board was for us to make our own independent recommendation as opposed to just a recommendation to OPA. I also am, I think I'm persuaded by what the Howard students have said today, that perhaps what we should do is in the regulations remain silent on what the actual application is. I agree with the decision of the board that in the short term we should use the DOJ application. At least in the short term we should use the DOJ application, because I think it's the only way somebody, at least right now, is going to actually be considered for clemency. And so I would not want anybody to think that they've applied for clemency in a way that we know is not an effective application. But I think my personal view in any event is that as Professor Ross and the Howard students mentioned, having the regulations remain silent on what the application is would allow the board to be flexible if circumstances thereafter change and the White House counsel's office is willing to seriously consider applications that come directly from the Clemency Board without the OPA application.
Does any other board member want to respond?
Sure, Patrick, I would like to.
Sure.
I just want to say thank you so much to Ms. Meningo, Worley, Jenkins, and Professor Ross for your comments. We take them very seriously. They're very important to us. I just want to echo what Patrick and Emily said, is that we would very much love to receive these comments from you. And if you could send those to clemency@dc.gov, we would hardly consider them. But one thing I want to highlight that Emily mentioned is that if we look at the statutes, yes, the statute does require us to also send a letter of recommendation to the President of the United States. And so currently we're looking to make that modification to the regs to not only have the letter of recommendation go to the Office of the Pardon Attorney, but also go directly to the President of the United States. And that is something we're highly considering. And I believe that will also offer us the flexibility should we have a pipeline directly to the President for clemency, that that will give us flexibility in the regs. That has not been finalized as of yet because we're still going through notice and comments. But if we highly encourage that you send all of those comments to us so we can consider them. And a big apology that you did not receive the regs ahead of time. You know, our intentions were to send them to all the stakeholders, and I think we fell short on that part. So Professor Ross, an apology on our end, but we're strongly considering that your comments with a lot of value. So I don't want you to think that we were not sending them to you. That was not our intention. So we hope to receive your comments going forward by the 13th of September.
Patrick? Patrick?
Andy, go ahead, please.
Yeah, thanks. I have a question for the Howard students and professor. Do you think the statute requires us to make a recommendation to the president whether or not the offender has applied to OPA, or would it be sufficient to send a recommendation regarding an application to OPA to the president? In other words, do you see us as a parallel OPA process or advisory to an existing application that we don't just send to OPA, we also send to the president?
Great question, Andrew Foyce. First of all, there's the intent of the statute and also the wording. So certainly focusing mostly on the intent of the statute is to create a different process. In other words, to create a process whereby the president acts almost like the governor. Like we make the or you, the board, creates the application, figures out what you think is important, partly based on the statute, but there's some wiggle room. and make your recommendations. Only sending the recommendations where you think clemency should be granted. They're sent to the OPA and to the White House, right? So the statute's very clear on that, that OPA gets a copy of what your decision is after you hold a hearing, gather all the information, etc. But the idea of it being just a letter of recommendation to OPA, that was not intended by the statute. That might be what's being required right now because of the way this particular administration's working. And I think the board's right to be flexible and work with, what you're getting right now from the Biden administration. But the intent was its own pathway.
I say thank you very much.
Thank you. I had a question to Christina that I put in the chat.
So Professor Ross, you said once you make the modification, will the comment period be extended? Do you mean the modification to the regs?
Yes.
So in addition, so what we want to be able to do is that is a comment that was received to us, and so it's considered part of the notice and comment period. And so it will be considered part of the finalized regs. And I also want to emphasize, Professor Ross, is that while there is flexibility, while the regs do end up being finalized, that does not cement them in stone. They can be modified, they can be changed as we see fit and as we grow and become more flexible, because as you know, different administrations join. And so what we establish now with the Biden administration may not be what will continue on going forward with the next administration. So the regs are definitely, the way that we're creating them is so that they have more breath in them, in the sense where we can make changes to them. This is just, unfortunately, as you stated, what we're offered to work with the current administration.
Okay, are there any other comments from the public at this point?
This is not a public comment. Oh, sorry. Do you want me to wait?
No, I absolutely don't. Please.
Okay. So I would agree with Emily's point about having flexibility in the point of the Howard Law students and having flexibility in the regs by not specifically referencing the application. The application itself from the Office of the Pardon Attorney is a really important step to make sure that individuals who do fall under any federal initiatives are considered, and that an individual who instead completes a DC application does not erroneously believe that they are being considered for a federal initiative. So I think a really important step for the board to take would be to advocate with the Office of the Pardon Attorney before they embark on any initiative. So now to change some of the language in the application to make sure that it includes individuals who have DC code offenses, so that there's a box to check for Superior Court. Sort of really small changes, but changes that will make it more applicable and more easy to fill out for individuals who have DC code offenses.
Thank you. So point well taken.
And I'm happy to participate in that in the next meeting with the Office of the Pardon Attorney.
Fantastic. That would be great as well. Thank you. Okay. So I just want to reiterate where we are. September 13th is when all the comments are due. They go to clemency@dc.gov. We urge you to get those comments to us formally in that venue, and would welcome and will seriously consider every single comment that comes. As you can see, this is a board that intends to work with the community and to really allow us for the greatest flexibility to get this done and to improve on that very sad statistic of one DC applicant since 1989. So with that, I'm going to ask if there is a motion to adjourn.
So moved.
Second?
Pat, I couldn't find my mute button, but I'll second the motion. But I just wanted to state something because I really appreciated the Howard students and especially that statistic, because I remember when I was on the CIC, I visited over 50 BOP facilities, and I'm watching out DC residents, and they didn't have a chance, and they were losing hope where they were. But this process, even though it may be bumpy getting started, it's got started because we're having these discussions. Before, we wouldn't have had these discussions. So I'm just appreciative for them coming forward and with all the information. And I believe they will, give us the information that they have, put it on our email so that we can go move forward with this and let their voices be heard as we move forward because we need them. And
Thank
I second the motion. Close.
Thank you so much for that. Okay, so motion to adjourn. All those in favor? Aye.
Aye.
Opposed? Okay. Thank you very much. Really appreciate the work that the members of the board are doing, and thank you very much to our community members as well, particularly our University Law students. Thank you. With that, we're done. Thank you.
Thanks, Pat. Thanks.
Thanks, Pat. Bye, everyone.